Well, we've reached the 10:45 time frame for the start of our second session here at the Max Planck Law Annual Conference. I wanted to say a few things before introducing our keynote lecturer about the Max Planck Law Network. It's the case that the network consists of the 11 law-related institutes in the Max Planck Society. That includes the work of more than 20 directors, leading research teams of over a complete number of 400 researchers at various levels of their careers. And of course, it also includes guests and alumni. It's an impressive network and framework of legal research, perhaps the most impressive in the world. And we're confident in making that claim today because we are thrilled to be able to welcome as the keynote lecturer for this year's annual conference, Professor Anna Peters. We could hardly hope for a better, more inspiring anchor for our discussions today around the theme of rights inflation or rights realization. Professor Peters is the current managing director of the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, where she leads research projects devoted to global constitutionalism and global governance, as well as the individual in international law. She is also a world-renowned pioneer in the field of global animal rights, and that work especially informs her role in our discussions today, because it pushes new horizons for the role of law and of rights, including new substantive rights protections, as well as rights holders and rights claimants. All of this work draws on Professor Peters' expansive competence in areas encompassing public international law, including its history, global governance, human rights law, international humanitarian law, the law of international organizations, European Union law, comparative constitutional law, and constitutional theory. She's published widely in these fields. Representative recent publications include the 5th edition of the Standard Work on Public International Law in German, the book Global Constitutionalism from European and East Asian Perspectives from Cambridge Press, and 2016's book Beyond Human Rights, also from Cambridge University Press. Prior to assuming her role at the Max Planck Institute in Heidelberg, Professor Peters was for a decade the chairholder in public international law and Swiss constitutional law at the University of Basel. She has visiting affiliations at universities in the United States, in France, and in China. Professor Peters was a fellow of the Wissenschaftskolleg in Berlin. She is the past president of the European Society of International Law, and she completed her studies and academic qualifications at universities in Würzburg, Lausanne, Freiburg, Cambridge, Massachusetts, and in Kiel. I can say from personal experiences as a frequent guest at her institute in Heidelberg that she is also a welcoming and supportive host of guest researchers, and I have been marveled at the profound way in which she mentors the researchers in her team. As a final personal note, I'll say that if you visit Heidelberg and have the opportunity to take one of Professor Peters' brisk lunchtime walks with her, you'll be left gasping for breath, not only because of the pace at which she's able to maintain her walks, but at the breadth of her intellectual curiosity and generosity. I'm so thrilled to be able to welcome her into this discussion today, not only because of how she'll illuminate and enlighten our conversation, but because she so profoundly exemplifies the best of what the Max Planck Law Network is. Thank you, Professor Peters.
Thank you, Russ. I hope you can hear me. Could you just confirm that?
Yes, yeah.
Wonderful. Thank you so much for these totally exaggerated and flattering words. Russ, I got to know Professor Miller at the Wissenschaftskolleg, actually, during the fellowship he mentioned, because he was part of a expert committee translating the recommendations of the Deutsche Wissenschaftsrat into English. And I recall that Russ is a very nice dancer. When colleague Stefan Vogenauer suggested as an overall theme for the second Max Planck Law meeting, the topic of rights, I was immediately thrilled because I think that this is a topic which spans all the fields of interest of the various law institutes and is actually a very hot topic currently. On the handout, which I hope you have received, I quoted the Kenyan-American professor Makao Mutua, writing, "The balloon of human rights has certainly popped, but there is no alternative and compelling idiom to fight injustice and mass catastrophes." Writes Mutua. He was one of my teachers at Harvard Law School. He's now a professor at Buffalo Law School and espouses what is called a critical third world approach to international law, a TWAIL perspective. And this diagnosis by a TWAILer can be contrasted to the report of the US-American Commission on Unalienable Rights, which was released this August. This commission had been established by the US Secretary of State, Mike Pompeo, who is, as you know, a member of the Republican Party. And the chair of that commission was Marianne Glendon, also a Harvard professor. She served as the US-American ambassador to the Holy See for some years. That report writes, I quote the report, "There is good reason to worry that the prodigious expansion of human rights has weakened rather than strengthened the claims of human rights and left the most disadvantaged more vulnerable. More rights do not always yield more justice." End of quote of the report. So here you see a rare example of complete agreement, complete consensus between a TWAIL scholar on the one hand and a Catholic-dominated conservative think group on the other hand. If both agree, then there should be a lot of truth in their findings, I would say. Have rights, especially human rights, been blown up so much that they indeed popped? Do we need an alternative legal language to fight injustice? In my 30 minutes talk, I'll try to argue that the balloon has certainly been blown up quite a lot, but that it has not yet popped. Surely not for those who are rightless, deprived of rights. Rather, the pricking the needle into the balloon is a cheap intellectual exercise for those who are enjoying rights. But it's not for those who are deprived of the rights. I argue that we should be wary from blowing the legal concept of rights up too hard, and that we need complements to rights, but not alternatives to rights. Rights, especially human rights, may be not enough, as Samuel Moyn writes, but they are necessary and indeed indispensable legal instruments for protecting weak and vulnerable members of society. Rights are an eminently useful legal instrument which must be upheld and refined. And I'll now follow the handout which the organizers sent around. We first have to examine what rights are. Rights have been and are being discussed by political philosophers as moral rights, but I'm here speaking about legal rights, which of course build on the moral pedigree of rights, but which have the binding force of law. Technically speaking, we can distinguish rights as subjective entitlements from objective protective standards, the law. Just like in English, the Roman legal language had two different words, jus as opposed to lex. The Roman terminology in reality does not fully match the contemporary distinction between law and rights, but it is an easy marker to remember the distinction. Here's an example for explaining the differences between these two types of legal institutions. The painting of the Mona Lisa. You are prohibited from scribbling on the painting of the Mona Lisa. However, Mona Lisa has no right not to be scribbled upon. She cannot have such a right because she's no person in law, but only a thing, a painting. That's the difference between objective law and subjective right. In modern law, roughly speaking, since Immanuel Kant, legal rights are considered to be the basis of the legal duties of the other side. For example, I have an intellectual property right over the content of my talk, and you are obliged to respect it and may not plagiarize me. It's not the other way around, that my right flows from your duty. That sounds technical, but it makes an important difference because it leads to a quite open-ended quality of my right. It's not exactly clear who is bound to respect my intellectual property right. The shift at the end of the 18th century European Enlightenment philosophy from the concept of duty to the concept of right as the foundational concept of the moral and legal fabric was extremely important. And maybe this gives rise to some of the problems of today we are talking about now. Taking the rights as the basis and as the starting point also means that one right can generate multiple duties, and that not only the addressee, but also the substance is open and can evolve further dynamically. For example, the human right to private life may evolve to an entitlement to have one's gender changed in a birth register, or the right to privacy may evolve into a right to erasure on the internet, or the right to bodily integrity may evolve into a right of protection against environmental pollution, and so on. Another distinction which I put on the handout is the distinction between public law and private law, a continental distinction. In the field of private law, rights and obligations can flow from legal instruments which parties conclude among themselves, notably contracts. In public law, rights are enshrined in legal instruments. And the best known type of rights are, of course, the fundamental rights guaranteed in the constitutions of rule of law-based states. I just gave examples from domestic law, but rights have been, since 1948, also codified in international law, beginning with the Universal Declaration of Human Rights. Those authors, I mentioned them on the handout, page 2, those authors who deplore the proliferation of human rights point out that we now have 64 international human rights related instruments with a total of 1,377 human rights provisions, which a country that ratified all 64 instruments would have to comply with. Naturally, these authors speak of over-regulation at this point. I think that the legal landscape in international law has another problem. It is too simplistic. I think the status of the individual human being in international law should be seen more nuanced. The prevailing idea is that under international law, individuals have human rights. Otherwise, if they had no rights, human rights, they were no international legal person. That's the traditional view, and some people even adhere to the traditional view and say individuals are still only objects, not persons, in international law. I think that this view is too primitive. We should acknowledge that there are different types of rights. Some are fundamental rights, others not, also in international law. For example, there are rights under international environmental law, labor law, refugee law. These are often connected to human rights, but not all of them are in themselves so important that they deserve the label fundamental right. The recognition of different levels of international rights would be one way to counter the reproach of a human rights inflation or proliferation, which I mentioned. I'm now moving to section 2. What's the rationale or the basis of rights? This is highly disputed with regard to human rights. It is often said that humans have human rights simply by virtue of being human. That is, in a way, the definition of human rights, their quintessential idea. Historically, in the theological strand of natural law, the idea of rights for humans was explained with the immortal soul of man as the image of God. When this no longer holds and held, the new secular strand of natural law pointed instead to the rational nature of humans. Today, it is fashionable to consider human dignity as the basis of human rights. But this doesn't solve the problem, because dignity is a kind of quasi-religious foundation too. Why humans enjoy dignity and only humans begs the question. It is difficult to explain why humans, as opposed to animals, for example, should enjoy dignity, and therefore only humans enjoy human rights. It's difficult to explain that if one doesn't want to draw on metaphysics. One of the foundational human rights texts, the US American Declaration of Independence of 1776, to which the US Pompeo Commission of Unalienable Rights, of course, alludes, this Declaration of Independence begins with the wordings, I quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights." End of quotation of the Declaration of Independence. So the Declaration points to the religious foundation, but it also kind of gives up reasoning by saying this is self-evident. Today, the British political philosopher Joseph Ross also gave up and says that international human rights should be seen as without foundation, simply arising out of the practice of intervention. However, it's not superfluous to think about the basis of rights, because depending on what we consider as the ultimate justification of rights, this determines the substance which rights should be acknowledged. And it also determines, importantly, who can and who should enjoy legal rights and who not. A standard justification which is closely related to man's ostensibly rational nature is the protection of autonomy. Rights are legal institutions which protect the autonomy of persons so that they can choose for themselves what is a good life for them. This is, of course, a typical Western justification, one could say. Another explanation, in a way the counterpoint, is looking at the vulnerability of persons, the vulnerability against forces of nature and against the brutality of other humans. This is a more feminine or even feminist explanation of rights. Vulnerability has become an important legal concept in international human rights law. In order to protect especially vulnerable persons, such as women, children, migrants, refugees, civilians in armed conflict, and so on, special sets of rights have been created. Vulnerability points more to the corporal, to the bodily existence of man as the poor, bare-forked animal that is man, as Shakespeare has King Lear say. As I said at the beginning, rights, especially human rights, have been much extended in the 20th century. So let's look a bit at these extensions. 30 years ago, many spoke of generations of human rights, liberal and political rights as the first generation, social, economic, and cultural rights as the second generation, and group rights such as the right to self-determination or the right to peace, as for example mentioned in the African Charter of Human Rights and Peoples. That was called the third generation of human rights. Today, some speak of environmental rights to a clean and healthy environment and rights to environmental information as enshrined, for example, in the Aarhus Convention as a fourth generation or type of human rights. On the international plane, the political and civic rights on the one hand and the economic and social rights on the other hand have been, as you know, codified into different treaties, but at the same time in 1966, exactly to accommodate the divergence of opinion between the two political camps. The Western world found that the political rights were the real human rights, whereas the socialist bloc said that what actually matters are the economic rights. And therefore, there was the split. We could variate the famous quip of Anatole France, who needs the freedom to sleep under the bridges of Paris. It would be a right only for the rich. In contemporary international law, human rights of all types, under the mantra of the unity and interdependence of all human rights, have now gained much traction. Human rights are impacting on the entire fabric of international law. One could say that human rights radiate into all the subfields. It is now acknowledged that each and every subfield of international law must be interpreted in the light of human rights. Sometimes the human rights have the function of a counterpoint. For example, they place limits on the protection of foreign investment. The same applies to economic sanctions. Here, the obligation to interpret legal instruments in the light of human rights has become most prominent. When the Security Council mandates UN member states to adopt targeted sanctions against terror suspects, the European Court of Human Rights has asked the member states of the Council of Europe to interpret the relevant Security Council resolutions in the light of the human rights guaranteed by the European Convention on Human Rights. Inversely, and frequently, human rights are no counterpoint, but rather reinforce and work in the same direction as the rules of other regimes, for example, in the law of refugees and in the international law of armed conflict. In many areas, an explicitly human rights-based approach is being called for. This was maybe first done in the international law of development cooperation. I think it was invented by the then Human Rights Commissioner, Mary Robinson, around the turn of the millennium. The human rights-based approach to development cooperation was considered as useful because it provided clearer legal benchmarks and allowed to assess the performance of development aid against these benchmarks. It thereby contributed to legalizing the entire field. Or, to give another example, the international law on combating natural disasters also says that human rights must always be the yardstick. Human rights also deploy procedural functions. Human rights impact assessments are required before transnational projects are started. For example, the UN Committee on Social Rights demands that states, before concluding new investment protection agreements or before concluding new trade agreements, that the states must conduct a human rights impact assessment. A similar procedural tool is so-called human rights mainstreaming, which means that all the elaboration, adoption, and implementation of legal instruments and policy instruments must at all times take human rights into account. Besides this extension in substance, the duty bearers have also been expanded. Human rights had been invented as rights against the state, because the state has the overwhelming both physical and legal means to threaten and destroy humans, beginning with putting them in jail or camps, killing them with help of the state's army and police force, torturing them, and so on. In today's world of global capitalism, transnational business actors also have enormous power over persons, an enormous power to harm, hurt, and even destroy human lives, either directly by hiring them for labor in inhumane, dangerous, unhealthy, and low-paid work conditions, or indirectly harming them by polluting the environment, dumping waste, setting up firms and infrastructure by drawing on forced labor, or with help of the military in authoritarian states. It is therefore urgently needed to rein in the power of business. However, I think that simply tying business to the existing international human rights is not the solution. We need a better adapted toolkit which takes into account the different type of power that business deploys. Along that line, the draft treaty, which is currently discussed in the United Nations Human Rights Council, goes in the right direction. Besides the extension of the addressees of rights, there is also the question where human rights deploy their effect. In our globalized world, everything is connected. Police and military activity or surveillance activity crosses the borders. The United Kingdom set up internment facilities in Iraq. Our emails travel over servers in Ireland and the United States. When the European Union subsidizes European farmers and gives export subsidies to them, then this has repercussions for Asian and African farmers who cannot sell their products easily in the European Union, and maybe the market There, the local markets risk to dry out. All these transnational activities and transnational effects might be examined under the perspective of human rights. The question then is whether the state is bound to respect the human rights of people, say, in Iraq, Bangladesh, or India, when and under what conditions. These questions are discussed under the heading of extraterritorial binding force of human rights. They are extremely complicated and are not yet resolved. The next question is, rights for whom? When rights were invented in the 17th and the 18th century, they were called universal. But in reality, they were reserved for a very small circle of the privileged, happy few. People without property, people who did not pay taxes, women, peasants, slaves, did not enjoy any rights. For some strange reason, the contradiction between the universalist language and the exclusivity of rights holders was not seen then. Today, post-colonial scholarship finds that even nowadays, rights have not been properly and fully decolonized. Because, in fact, rights are still being withheld, says the post-colonialist critique. These groups are still rightless and are inferior to the privileged. The infinite detainment of terror suspects, the inhumane conditions in asylum camps, our complicity in exploiting laborers and poisoning the environment in the cheap sites of production for business controlled from the north are examples in point. I personally think that the extension of the circle of rights holders should go on and should extend from humans to animals and natural entities. Courts in Argentina and Colombia, India and Pakistan have awarded certain rights to animals, notably to apes. I put you the references on the handout. The courts here often point to the intellectual and emotional capacities of the animals, notably to their sentience, their capacity to feel pain and suffer in confinement. And courts in the same countries have acknowledged rights of natural entities ranging from the Amazonian forest over the river Ganges, the volcano Taranaki and New Zealand and other. These court decisions often rely on the spiritual heritage of indigenous populations, and they justify the rights of nature both by practical needs for stronger legal protection and by the holy nature of the entities, rivers or mountains. Given the extraordinary career of the legal institution of rights, it is not surprising that critique is being voiced. The criticism is both analytical and political. Some critique is leveled against the institution of rights as such, for example, in opposition to a legal order based on duties or even on virtues. Or, for example, Roberto Gargarella deplores that the Latin American constitutionalism focus on rights neglects what Gargarella calls the engine room of the Constitution, namely the institutions such as parliaments and the executive branch. Another strand of critique particularly attacks the endorsement and protection of rights on the international level. Here, the well-known critique is the cultural critique, which deplores that human rights are a Western invention, which does not fit in the rest of the world, notably to Asian values. The critique is that human rights have been imposed and were and still are used as a pretext for colonization, domination, and what is today called informal empire. That what was called civilization was in reality exploitation, subjugation, and extermination of non-European peoples. The critique is that this perverse civilizing mission is continuing in the shape of intervention, war, and economic domination to transnational corporations whose profit goes to the Western owners and shareholders and consumers. The critique blames rights inflation, rights overreach for this development. The critique speaks of a rightsification of an undue righting of legal regimes and fields. This criticism is not without merit. It can be questioned whether we really need a right to a microcredit, a right against corruption, a right to breastfeeding, and a right to the city, to mention only some of the new rights currently proposed. The backlash against rights feeds on different intellectual paradigms, as I already mentioned at the beginning. In a neo-Marxist framework, rights are only the superstructure over the material conditions of production, and in the end only serve to protect the bourgeois property. Critical legal studies and large parts of the third world approaches and post-colonial approaches, and also some feminist approaches, are often adhere to this view. A different attack comes from thinkers who place high value on democracy and the political process. This is much en vogue in the United Kingdom. Thinkers along these lines see rights as an undue legalization, which takes away things to be decided in the political process, and gives also too much power to constitutional courts, which adjudicate on these rights. So the reproach here is both the reproach of a depolitization and of an inappropriate gouvernement des juges. This unwanted government of judges is of course seen as more problematic when the judges are international judges, for example, sitting in Strasbourg. This critique risks to flow into the populist critique against courts and against international organizations as supposedly elitist institutions which don't pay attention to what the people really wants. Another strand of critique is more communitarian, skeptical of what Marianne Glendon called a mere rights talk in a nation under lawyers. This line of critique opines that a society can hold together only if people do not constantly reclaim their egoistic rights, but are ready to compromise and are more solidaric. These scholars place more emphasis on responsibility and overall build more on what we might call civic virtue. Finally, the neoliberal critique is specifically directed against some rights, notably against the current intensification of social rights. For example, Guillermo Verdirame points out that it is a problem to mention torture in North Korea. He doesn't mention torture in a secret CIA facility, as an aside. It's a problem to mention torture in the same breath as cutting back development aid and calling both a human rights violation. That may be an undue leveling of injustice, says the neoliberal critique. As already mentioned at the beginning, these various critiques come from totally different, even opposite camps in ideational and ideological terms. One could say that there is an unholy alliance against rights among the different theories, spanning from Marxism to neoliberalism. What are the reasons for this backlash now? I think there are several factors playing together. First, delusionment. Delusionment about the expansion of rights on paper without sufficient attention to implementing the existing rights. The rights have become paper tigers. Second, there is a repulse against double standards and hypocrisy of the West. States of the non-Western world are asked, with carrots and sticks, for example, conditionalities in lending, they are asked to respect human rights, while they see at the same time the rich states of the North and West to detain refugees, that migrant families are separated in the United States, that drone strikes are conducted which produce civilian casualties, and that the Western lifestyle seems to benefit or is seen to benefit from unhealthy labor conditions and cheap labor in the host states, in the states where the production sites are. Third reason for the backlash, there is a globalization fatigue. The wealth trickle-down effects through trade liberalization and foreign investments have not reached everyone, not the most poor and abject. Material inequality of wealth and income is rising steeply. A fourth factor is digitalization. People see the difference of living conditions at the other end of the world. In former times, a young man from sub-Saharan Africa did not know exactly how we lived here. Now we can see it every day, even in a much idealized picture on social media, films, YouTube, and so on. So he no longer accepts his fate to live in misery. Fifth, and most troubling to me, is that the backlash is in line with the shift of political and economic power in the world. States without a deeply rooted rule of law tradition and without a deeply rooted democratic tradition, with, on the contrary, collectivist, anti-individualist traditions and more accustomed to a top-down governance style, or, as in the Arab region, with a non-secular tradition and partly religious fundamentalism, these states are on the rise. The religion-based ethics are duty-based ethics, not rights-based, starting, of course, with the duty towards God. For me, as a legal scholar, it is sobering to perceive that rights are in decline while this power shift is occurring. The parallelism might not be a coincidence. I think it shows how the law is only, to a large extent, an epiphenomenon to politics and the economy. When that shifts, the law shifts as well. Now I'm coming to my response against this unholy alliance of critique of rights. From the left to right, I would like to argue in favor of rights from a practical perspective, without speculating too much about the justification of rights, but just pointing out the benefits of rights. I think this practical approach is in line with the simple observation that the intellectual backlash against rights, which I described, is apparently not deterring people all over the world, from Venezuela over Nigeria, Bangladesh, and Hong Kong, from reclaiming their rights. They still want rights. So let's look at the good job that rights perform. First of all, classically, rights have been considered a vehicle of emancipation. It has been said that rights transform victims into citizens. This is surely extremely important and continues to be valued. However, this rationale could not explain animal rights, because animals can never reclaim their rights in the streets or go to court by themselves. The second important benefit is that rights, for example, the right to physical integrity, to bodily integrity, the right to move around freely, or the right to housing and food, all these rights protect the vulnerable body more than the intellect. It is telling that the writ of habeas corpus was historically the first human right. Rights protect exactly the imperfect body. Rights are not the price for the smartest and the fittest, for the best and the brightest. Every other view about rights would end up in ableism, in discriminating and excluding those who are intellectually weak, physically disabled, and mentally disturbed. But I think that's exactly those members of society who needs rights the most. And then this would also include animals, the weakest in our societies. Thirdly, and importantly, rights trigger an obligation to justify. Rights are a fallback position. They trigger the duty to explain and give evidence. If a right to bodily integrity is the starting point of legal reflection, taking away the living space and mutilating and killing somebody cannot be done without further explanation, and trivial and banal reasons would not be sufficient. Curtailing a right needs to be specifically justified in a rational procedure. The reasons must be mentioned, they must be explained, and they must also be proven in certain procedures. Because of this function of rights, as triggering a justificatory process, rights have been fittingly called, not trumps as Ronald Dworkin would have it, but as prima facie legal positions. The legal institution of rights leads to a culture of justification, as opposed to a culture of authority, to quote the legal scholar and South African Constitutional Court judge Etienne Moerainik, who had fought against the system of apartheid. This discursive and burden-shifting function of rights suggests that rights should be codified and protected not only on the domestic level, but also on the international level. And this discursive function is also eminently useful for animals. The critique against international rights as being just a moral crusade of the West against the rest, and to a large is, I submit, to a large extent unfounded. It is true that historically rights have been abused by Western invaders and colonizers. However, the current pushback against rights in those regions is to a large extent pretextual and is a cover-up of the ruling elites, of ruling political parties, of dictators, oligarchs, and the super rich in countries whose leaders do not care, or in any case do not listen, and are not accountable to the population on the ground. We should not forget that rights have always been reclaimed and fought for exactly against the dominant culture and against the establishment. Rights were reclaimed by European middle class against the nobility who was in power. Rights were reclaimed by laypersons against the church. Rights were reclaimed by women against men who dominated them. Now the question arises whether rights should also be acknowledged for animals, although they cannot fight for these rights themselves. So I think that the cultural argument must be examined very carefully. Of course, international rights must leave a certain deference to the culture on the ground. However, the question remains, where are the limits of this deference, of the margin of appreciation, as the Strasbourg Court says? Certain habits and traditions are not worth protecting simply because we call them culture. There was a culture of binding women's feet. There still is a culture of mutilating women's genitals and a culture of eating animals. These collections of stupidities and cruelties are not worth protecting, as little as the prohibition for women to drive a car and the practice of marrying children at the age of 10 is worth upholding, I would say. In order to find out whether women want to drive a car or want to be married at the age of 10 to a 50-year-old man, we must ask the woman, not her husband. In order to determine which interests and which behavior needs the specific and stronger protection in the form of rights, we have to ask the people concerned. First of all, people obviously vote with their feet and migrate away from societies in which their needs are not met. Of course, meeting their needs does not necessarily require legal protection in form of rights, you could say. So we have to study more closely and empirically what people want and how their preferences might change. On the handout, I give you the link to an international social science project founded by the US-American political scientist Ronald Inglehart. This project consists in polls, opinion polls in the entire world. One finding is that the preferences of people change indeed with the change of the society they live in. When there is a threat to the physical existence through violence, criminality, war, and hunger, people favor what the researchers call traditional values, such as hierarchy in the family and so on. When their physical existence becomes more secure, with less war, less crime, and less hunger, then people start to cherish more autonomy and choices. That's the findings of the polls. I find these results intuitively quite plausible. The results also explain why in a situation of globalization fatigue, in a situation of a growing disparity of wealth, with new insecurity due to macro trends such as global warming, environmental degradation, and not the least pandemic, the turn back to these traditional values is going on. But in this climate, we should never forget that rights are, to paraphrase Rosa Luxemburg, needed exactly by the others, by the ones who are deprived. They are not needed by the ones who have the say and who have everything, like us.
Professor Peters, thank you so much. If you want to make sure that you've concluded your remarks, we're receiving some questions now, and I assume that you are available to receive some of these questions and answer them. I can pass some of these thoughts along to you. One question that has come in asks or remarks that you presented a kind of eclectic range of methodologies as a possible basis for the foundation of rights. Perhaps at times referring to their metaphysical foundation, particularly approvingly referring to the spiritual or metaphysical foundations for the recognition of animal or natural entity rights in some jurisprudence. But also you've made reference to positivistic, which in some sense are classic political commitments as a foundation. So the question is whether in this discourse that so-called eclectic approach is acceptable, or must we actually settle on one or some other methodological foundation? That's one question that's come through.
Should I answer the question immediately, or do you want to collect? Yeah, sure.
That will give me time to then.
Yeah. Okay. Yes. So on the handout, I mentioned only 3 justifications because I thought those to be the ones which are currently most en vogue. I mentioned dignity, autonomy, vulnerability. Dignity as a foundation is mentioned in many constitutions. It's also mentioned in the UN Universal Declaration on Human Rights. It's famously as a model for other constitutions of the world mentioned in the German Basic Law. And it is also used as a distinction to animals, that men supposedly have dignity, animals not. I think, as I said, this is question begging, and dignity, in my view, currently espouses a quasi-metaphysical place. Autonomy has been is classic Western enlightened thought. There is the book by the Oxford philosopher James Griffin, which builds his entire, which is a strong defense, book-length defense of this basis. Vulnerability is more en vogue in feminist quarters. And I think, to answer the question, that we don't need to settle on one single justification. I would even say that, for example, rights for animals have a different justificatory basis than rights for humans. I suggested to look at what are the practical benefits. These can be multiple, and these can be also different for different types of actors.
Great, thank you. I should say as an interim point that one issue or question that has come through repeatedly is the well-justified compliment. Will you please make these remarks available for publication in some way? A sign of great admiration for the sweeping and insightful nature of them. Thank you. Another question that has come through is that that you remarked on a kind of equivalence. You called it the unholy alliance of the critique of rights. The question, I guess paraphrased, is whether you're willing to equally credit the critiques that come from those 2 maybe political poles. Do they have the same bases or foundation? Can you distinguish the bases and foundation? And are you willing to say that one of the critiques is better founded than the other?
I think I don't want to do that here now in the talk, and it's also not, I don't think that it is necessary. Of course, I think most of the critiques has some kernel of truth in it. And of course, each of these critiques has, again, variations and so on. What I painted is a quite rough picture, for example, by putting Marxism, neo-Marxism, Twale, and so on in one bowl, which is, of course, much too simplistic. I think that the critique already have, in combination or isolation, contributed to hesitation and rethink, and that this is salutary. And my response was that, first of all, we might have to nuance, and therefore my suggestion, which I also made in the 2016 book, is that in international law, we don't need international human rights all over the place, but we should say that there are some rights which are rights, but not human rights, and they have a lower status, one could say, but they are still useful legal institutions for practical reasons, etc. And this, I think, would be is a possible response against the critique that there is inflation and overreach. The other pathway, which was conducted by this Pompeo Commission, was pretty clearly to signal that we have to cut back human rights and make the group of human rights which are really worth defending much smaller. So the critique, the critique from the Global South of double standards and hypocrisy is, I think, for international lawyers very, very important. But it's, I can't say only one critique is right and the others are wrong. I think they all have something and we have to react to that. And I suggested a reaction, namely to think also of complements to rights, but not to throw rights away, to trash them completely. I think this would be very dangerous and would be really detrimental because, as I said, much of the critique is purely pretextual by those who subjugate and oppress and exploit others.
Great. I have a question that's come in that links back to the earlier question about the possible methodologies for founding our rights talk. The question asks whether concern about interests would be another possible justification for the position of animals or natural entities.
Yeah, that is a very nice question, and I only mentioned very briefly at the beginning the distinction between rights based in public law documents and rights in private law. And because I'm a public lawyer, I of course know the public side better. And also because human rights is the thing which is most discussed, I focused on that. But we should not forget that the whole debate on rights and their foundations is totally messed up by the fact that in the 19th century, these theories about rights flowing from interests as opposed to rights flowing from will, protecting the will, Willenserklärung, these theories were private law theories. And they had very much in mind the, so to speak, horizontal relationships between citizens / market participants flowing from contracts, which are again, of course, made possible and secured by the law of the state, but nevertheless, which are in this market setting. For the whole talk and the debate, this was the end of 19th century debate between Savigny on the one hand and I don't know exactly who was on the other side, and the focus on the will. I would really like to examine that in more detail. I think it is the typical male strongman type justification. And the opposing camp said, no, rights protect interests. And I think this is the, in this controversy, the interest protection is the better view. And this is the one which has carried the day, I would say. Also in Anglo-Saxon political philosophy, it's very much about that. Applying this to animals, this boils down to the fact that if you focus on will, you have a problem with justifying rights for animals, because it's difficult to show how the animal forms a will. It may be instinct driven, etc., etc. But if you say that the rights protect interests which we consider to be very important, notably the interest to be in a good state and not suffer, then this fits perfectly for animals. And I think the whole strand of vulnerability builds, of course, more on this interest thing.
I can build on the reference to vulnerability. A question that has come through asks whether vulnerability is necessarily linked to suffering, if those are equivalent ideas or constructs, and if so, how is suffering measured or quantified or calibrated? How do we know that suffering has taken place such that a right should intervene?
I think this question is very pertinent with regard to animals, because with regard to humans, whose reactions we know, they scream and we can relate to them because they react as we would do. So intuitively, we think we know how their pain and suffering feels, although, of course, strictly speaking, we can never exactly know and will never know how someone else's pain and suffering is, because it's somebody else. We only imagine that, and the closer and more similar the other is to us, the more we think we sympathize. So with regard to, I mean, the talk of suffering and so on is, again, philosophically comes from a completely different strand of reasoning, namely from utilitarianism, which says that justice or a good society should build on the absence of suffering and the presence of more happiness. And this utilitarian tradition is a different tradition from the rights tradition, but there are also fusions and intermergence. So concerning animal suffering, much progress has been made with regard to biological and medical findings on both physical properties, such as pain receptors, and also behavioral studies. And there is a famous text, the Cambridge Declaration on Consciousness. That's again another concept, but it's consciousness means to have to be aware of oneself, and that's of course a precondition for being able to feel pain. And then suffering can of course be physical, but can also be mental, etc. So we get there in deep, deep waters, and maybe the answer is that it's all also depending on scientific findings, which are provisional and reversible. For example, the fact that fish feel pain has been proven only some years ago. Before, it was denied for some reason because they don't scream and don't look like us.
Great. Well, I don't think you would object to the portrayal that the one questioner advances, that this has been a kind of defense of the rights position or rights talk relative to the unholy alliance of the critiques as you portrayed it. If it is a defense of rights, is it also an embrace of the extension of rights, perhaps even endlessly, the endless extension or expansion of rights? And that builds then towards a follow-up question, which is, isn't that only possible considering all the inevitable conflicts that will emerge if we are operating on the assumption or in the dependence on the proportionality principle? That is, what I guess the way to phrase the question would be, what about poor Dworkin's rights here? Who's going to defend him and his interests? Has he, in an embrace of an endlessly expanding rights regime, are we declaring the end of history, or to put it another way, the end of Dworkin?
Yes, I defended rights in the talk, but I also called for refinements and for other legal complementary strategies. Endless, the scepter or danger of endless extensions again has multiple dimensions. I spoke of extensions in space. I spoke of extensions in substance, namely right to clean environment, etc. And I spoke of extensions of who has the rights, not only monkeys, apes, but now also a volcano and so on. And there is the extension in opponents, duty bearers, business. So I think the question goes more to the extension in a yet different sense, namely, it points out that inevitably, if everybody has rights and even everything then has rights, there is a clash. So the rights cannot be absolute, they cannot be trumps. It's difficult to use the word nowadays, but we are speaking of a Dworkinian Trump now. But they are, of course, limitable. They can be curtailed. And that is the legal doctrine, of course, in all legal orders based on the rule of law, which acknowledge rights, that only one basis is absolute, and that is the supposed dignity, which is again seen as the basis of the rights. And therefore, for example, the right to be free from torture is also considered to be like a direct twin of dignity and therefore not limitable. At least that's the German doctrine. And if you write something else, you get career problems, as it happened to a colleague. So, so the normal way is, and that's inevitably, there must be compromises. And in order to draw these compromises and settlements, we have, as the questioner pointed out, the principle of proportionality. And there is, in line with the attack against rights, there is a strand of discussion which also criticizes the principle of proportionality, mainly for being too blurry and vague, allowing everything or nothing, which then also leads to too much power of the constitutional courts, which are the ones who say that something is proportionate or not. So the critique is that in the end, there is no legal certainty and foreseeability, and all is in the hands of the courts, which is additionally a democratic problem. Against this critique, that's a complicated discussion, and the point I would like to make is that the important, useful legal quality of rights is what I called a fallback position. It's less than a trump, but it is a starting point of the discussion which places the burden of explanation on the other side. So and the proportionality principle also exactly comes in at that point because it is asymmetrical. If an agency or a court is confronted with a right, then they have to examine to what extent the government may limit the right, but the agency and the courts, well, especially not the courts, they don't ask symmetrically what would be the optimal or best strategy for the government to do, but they only draw a line and say, stop, you can't go further than this because here we have the right. And this asymmetrical structure of the law created by rights as a fallback position simply leads to a stronger protection because of this discursive trigger. So it is, in a way, you could say, a constructivist and discursive advantage which the right brings into the legal order. Not more, but also not less. And for animals, this will be extremely important because now we kill, torture, mutilate, abuse, and so on animals all the time without any justification.
Great. Well, I've reached the end of the queue. I'd be happy to continue to have this conversation with you bilaterally, but we should be respectful of everyone's commitment and time. I'm so grateful for your contribution today. It builds profoundly on the great presentations we had at the panel this morning and deepens our encounter with this broad question. As you said, what entity in the world, but something like the Max Planck legal network with its broad-ranging competences across nearly every field of law is better positioned to grapple with these big questions. Thank you for today's great work and insight. I believe we've disabled the clapping hands function on Zoom. Unfortunately, you won't receive that feedback, but I can say that the comments for demands for copies of your remarks is a signal of how appreciated your presentation was. Thank you so much.
Thanks a lot. Thanks for the invite. Thanks for the questions. And I hope we can follow up also at some point physically and not only digitally.
Let's hope so. Let's hope so. I will say that we'll bring this keynote lecture portion of the program to a conclusion and urge all of you to return at 12:15, at which time we'll host a number of other directors of the Max Planck Law Institutes for a roundtable discussion still keyed to this theme. In the meantime, we'll step away for a bit of a break. I'll see you all at 12:15. Thank you, Professor Peters.
Yeah. Thank you. See you then. Bye.